We often wonder what is going to happen to our properties after our demise. What happens? How do we secure our legal heirs, our next of kin, after our demise, after we are no more? And the question that we always have in mind is, what are the legal processes, what are the legal proceedings that are involved in testamentary and interstate matters? And today I am going to discuss just that. Today I am going to discuss testamentary and interstate matters. Let us first understand the difference between testamentary and interstate matters. What is a testamentary matter? A testamentary matter or testamentary succession is one in which there is a will. It is one in which the deceased has made a will where properties are bequeathed or properties devolve to legatees based on the bequests contained in that will. On the other hand, interstate succession is where there is no will. Now, the major issue that we have to consider when we discuss the difference between testamentary and interstate succession is, how does the property devolve? What are the laws applicable? So when the property devolves under the testamentary succession, what would generally happen is the property would go as per the intentions or as per the bequests contained in the will. But when there is no will, that is in cases of intestate succession, the property will devolve based on the law of succession applicable to the person at the time of his death. Now, there are other aspects that you would also need to consider in your lifetime, not while deciding or discussing proceedings post the demise of a person. Certain things like the making of a will. My previous video has discussed the elements of a will. I will put the link to that in the comments. The other question is whether to make a will or not. The difference between a nomination, a legal heir, and the law of succession. I have done that in the previous video. I'll also put that link in the comments below. We will now move on to the aspect of testamentary petitions. Now, testamentary petitions would broadly be of two kinds: probates and letters of administration. And then on the other hand, we have intestate proceedings, which would cover letters of administration without will annexed and succession certificates. And in this video, we're going to see in summary what these proceedings are all about. Let us first take testamentary proceedings, and on that note, let us start with probates. What is a probate? First of all, when there is a will, you will need, post the demise of the testator, to probate the will. The probate of that will would mean the will is certified under the seal of a court of competent jurisdiction, granting the administration of the estate under that will. A note: wills of Christians and Muslims need not be probated under section 213 of the Indian Successions Act. However, a probate is always advisable because it makes the bequest, it makes the transfers or the transmissions of property under that will absolute. There is no doubt, there is no uncertainty. Who can file the probate? The probate can only be filed by the executor. You will then ask me, what if the executor is deceased, or if the executor for some other reason is not available to file the probate? Well, that goes to the second testamentary proceeding, which is letters of administration with will annexed. This is in cases where the executor or the executors are not available to move a probate. It is largely similar, but this could be filed by the next of kin, the legal heir, or any other person, including a legatee, that would be potentially interested in the property of the deceased or in that will. We will now move on to interstate proceedings. Interstate proceedings are proceedings where the deceased has not left behind a will. In such cases, there would be two types of proceedings: letters of administration without will annexed and succession certificates. Now, what is the difference? Letters of administration without will annexed is generally filed where there are immovable properties or immovable assets. In cases where there is no will and no immovable property, one could opt for a succession certificate. This is ideal when the assets largely comply of public provident fund accounts, mutual funds, bank accounts, shares, and other monetary and movable assets. Now, when it comes to testamentary proceedings, the next you would want to know is if you are not included or if you dispute the testamentary intentions of the testator. If you think that the will was made by undue influence or coercion, or for any reason that will was not valid and you wish to challenge it, what is the procedure? How would you go about doing it? The first thing you do is you file a caveat before the court before which these proceedings are pending. The next thing that you need to do is within 14 days of filing that caveat, you need to file an affidavit in support of that caveat. If the court is satisfied that sufficient cause exists, the court will convert the testamentary petition into a testamentary suit. Once the matter is converted into a testamentary suit, it will proceed like any other civil suit. Then one would ask me, is there a way out beyond litigation? Is there a way out to settle these matters? Yes, family arrangements, estate planning, and settlement agreements. These are agreements by mutual consent which could be arrived at in cases of interstate succession where the parties, the legal heirs or the beneficiaries, could settle the matter amongst themselves and have a document created reporting and recording the same. Broadly, these are the aspects of testamentary and interstate succession. But just a note of caution, while handling this, you should consult your lawyers to ensure this is done legally and professionally.